Welcome back to John's Briefs. I have one today that I don't know if I even want to bring up because it's going to cause a little spiciness. But I'm here with Terry Johnson from Firearms Legal Protection, and I want to talk to you today about whether or not your training record and the vast amounts of training you might have as a guy who's got a ton, if that gets is admissible in court. Let's talk about it. Today's video is brought to us by Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners with a 24/7 emergency hotline and plans designed specifically for self-defenders. They are offering a discount on their plan to Asp fans, so hit the link in the description for that. Terry, once again, I really appreciate you coming on the channel and spending your time. I appreciate Firearms Legal Protection's investment in helping get this education out there.
Thank you, and we appreciate you and what Active Self-Protection is doing. It's a great partnership. Thank you.
And we're also here at Wilderness Tactical today. They gave us some space for us to do some videos, and we want to say thanks to them for being a supporter of the channel. So, I mean, as a guy who has taken a ton of firearms training, right? I mean, I've got almost 1,000 hours of handgun instruction at this point. I've taken all the trainers and all these things. And in particular, there's one that's a big one, and I love Massad Ayoob. He is a friend, and he says I shoot good, and he watches my YouTube channel. And that, man, holy cow. In fact, I'm hosting him here in Phoenix this summer for Deadly Force Instructor.
Oh, great.
And one of the things that when I took Mag 40 was he said, okay, so what you want to do is you want to take all your notes from your class, type them up real good, do some peer editing and those things, so that way you know you got everything, and then put it in a envelope, seal it, mail it to your self-registered mail. Don't open it, so then that way, when we ask what level of training were you trained to do what you did, you know, so was this action in line with your reasonable training, then you can say, yes, it is, and I have this thing that can say I was trained beforehand and I know it was there. But I've heard that might not even be admissible in court. What are your thoughts?
Well, I agree. I don't know, one, how it would be admissible, under what theory, and if it were admissible, would it be used against you? And let me tell you where I'm coming from. Let's say you took a class 10 years ago, and you've got this envelope sitting here. Well, what if some of the things in the training have changed?
Oh, and they probably will in 10 years.
So are you operating off of what was done 10 years ago, or are you operating what happened a week ago? Are you operating off of, let's say, something along the lines of, this is what I've been taught since, did I do exactly what's in it? Do you remember what's in it?
Right.
So that's number one. The other part about this is, I don't know how any of this could actually help you. Because does this make you look like a, pardon the pun, a trained killer?
Okay.
So if I've taken all of the instruction, and again, I'm using it to show in what you're saying that I've acted reasonably. A prosecutor's going to say to a jury, well, let me ask you this. How many of you have taken 1,000 hours of classes? How many of you have done this? How many of you have done that? The question becomes at that point, just to me and my thinking, is what's the purpose of it and how is it going to help you in this particular situation?
Well, and so to me, I think that the theory becomes, okay, so did I act according to a reasonable and responsible standard, and was I trained in that? Did I do what I just thought was good in the moment, or did I do what a nationally recognized use of force instructor said was reasonable in the moment? I think the theory that comes out of that. And of course, you know, as somebody who does train a ton, my goal is to do the right thing in the moment.
Absolutely.
That's the goal at the end of the day. So when you say, why'd you take 1,000 hours of firearms instruction, John? Well, because God forbid I ever needed to use my firearm, I wanted to make sure that I had to use it, and that if I did, that I didn't use it recklessly or irresponsibly. And that seems to be reasonable to me. Would you agree?
I would agree that's reasonable, and I want you to think about it this way. What if you have a police officer who does the exact same thing?
Sure. He's hopefully got a bunch of training.
Hopefully the officer has a ton of training.
Yes.
And would any of that be used against them by, let's say, a defense attorney?
Oh, yeah, I would imagine that they can find a way to say, yeah, but you didn't, if you didn't do it exactly this way, and let's see what the policy actually says, and those kinds of things, and you didn't act perfectly, you could be in trouble.
Correct. So first of all, I don't believe it's admissible. I think training is great. I think you are 1,000% right. The more training you have, I firmly believe the better off you will be if you get in these types of situations. But sometimes bringing that training back in sometimes could hurt you.
Sometimes could hurt you. And also, I think something a lot of people don't recognize is that your character is really inadmissible in court. It's whether your actions met up.
Great question, and that depends upon how character is brought up. Anytime you take the stand, your character is always in play.
Okay.
So I'm not going to be able to say, I've never acted this way before. That's kind of putting character in. But the question with character becomes, at that moment, this is the type of character that you exhibited.
Yes.
So it's always in play, but it's not necessarily part of the play, if that makes sense.
Well, I mean, it's not a different than, okay, so I can't, if there was a bad guy on the stand, somebody that's being prosecuted for something illegal and evil that they did, I can't say, well, everybody knew he was a punk. And he did bad stuff before, so that means he did bad stuff now. And so it seems to me the other side, that's a hard time to say, well, wait a minute, is this there? Especially, if you don't testify on your own behalf.
Well, here's the thing. They have this thing, and most attorneys and folks who've been around the court will understand this theory, or it's a evidentiary rule 404B.
A 404 ruling, yep.
And what that means other crimes, wrongdoings, and acts. So it doesn't even have to be a crime. So if you've run down the street naked a few times, and
don't judge me.
And we can say, hey, John's done this several times before. You don't even have to take the stand for that to come in. I can bring that in through 404B evidence.
Okay.
So that kind of gets back, in a sense, to character a little bit. But again, notice I said it doesn't have to be a crime. You've done, how many times have John's walked, and this is not true, so let me say it right again. John's walked out of training 3 times, and he never had time, and he's a horrible shot, but he never put those things on his record. Well, and again, that's not true, so I'm just saying this several times.
It's not, but we're just saying for the sake of argument. Yeah.
But those things could come in to say, well, wait a minute, he's done this, he's walked out of training, he's had these records, so forth and so on.
So you could say, say for instance, we have a police officer who's a very detailed training record. Say, hey, I see in your training record you've been disciplined 3 times for not meeting training objectives.
Yes.
That can come in.
Correct.
Okay. So if it's salient to the case, that's a big deal.
That's a big deal, and here's the other part of this. What people don't understand as it relates to court in these self-defense cases, we truly don't go back to what you did 10 years ago, what you did 15 years ago, what you did a week ago. It's really about, in this case, at this particular moment, did you do what you were supposed to do?
Did these actions comport with the law?
That's all this is about.
Wow. So, again, why do we train? I think we don't train so that we can have a magic wand against the jury.
Correct.
We train so that we do the right things that comport with the law in the moment.
Absolutely. And training is a good thing. It is a great thing, because the better you're trained, the better you should respond to certain situations.
So, again, I have utter respect for Massad Ayoob. Understand how much I respect Mas and what he's talking about. And I have one of those envelopes sitting in my safe. I do. I'm a Mag 40 graduate, so I have one of those envelopes sitting there. Am I going to depend on that now? No. Does it matter for that? No. Do I still have my file on my computer that I can occasionally look back on and go, what did we learn in Mag 40? And what was the words that he exactly said? Yes. But don't expect it to be a magic wand against prosecution and against, oh, look, you did this wonderful thing. Because I don't think that's going to probably happen in a court of law.
No, and here's the thing. If you've gotten this far in the process and you're before a jury and you're taking the stand,
you're in a bad place.
You're in a bad place.
You in a bad place.
Yeah.
Terry, thanks for the knowledge, man.
My pleasure. Thank you.